Welcome back to the Deep Dive. Today, we are getting into something fundamental, something that's really the bedrock of any functioning society. We're tackling a concept that everyone praises, but in reality is constantly under attack. The topic is the supremacy of equality before the law.
That's a big one.
It is. And our mission today is guided by just a fantastic stack of sources, all researched and compiled by Mr. Zahir Ahmad Mir, focusing entirely on this theme. So we're not just, reading definitions. We're going to try and trace the uncompromising nature of this idea across different times, different systems.
Right. We're talking ancient history, global philosophy, and then right into modern law.
Exactly. From political morality to constitutional code.
And, this might be one of the most important things we could possibly talk about, because the integrity of this single idea, this concept of legal equality, is what separates a just society from one that's just run by, naked power.
That's a great way to put it.
I mean, think about it. If the law bends for the powerful, if it bows to status, then the whole system is arbitrary. Your life, your liberty, it all just depends on whether you've angered someone important. Understanding the supremacy is. It's the key to knowing if a government is real or just a performance.
And to guide us through this entire sweeping discussion, Mr. Mir's research gives us this one incredibly powerful ratio. It's a statement that's going to be our reference point for the whole conversation.
It's a great distillation of the entire concept.
It is. Here it is. Privilege ends where law begins. Just let that sink in. It's so precise. It frames this whole thing as a confrontation, right? A zero-sum game. And for you, the listener, I want you to hold on to that idea. When you look at what's happening in the world, when you see corruption or unrest, you're very often seeing the symptoms of a society where that ratio has completely broken down. Where does privilege not end? And how does that failure just warp the very fabric of everything?
It's the ultimate litmus test. It really is. And that's why we've structured this deep dive the way we have. We're going to follow that ratio. We'll start with this incredible historical moment of pure accountability.
A real-world test case.
Exactly. Then we'll see how that idea gets formalized into the global doctrine of the rule of law. And finally, we'll see how a modern country tries to lock it down in its own constitution. We're trying to show that this principle isn't, a cultural quirk. It's a prerequisite for any kind of stable order.
All right, let's do it. Let's start right there with the ratio itself, unpacking that core idea. Privilege ends where law begins. Okay, so let's focus on that word from our title, supremacy. When we say the law is supreme, we're saying it has this overriding authority. It doesn't just coexist with status or wealth.
No, it has to actively cancel them out in a legal sense.
Right, it has to nullify their effect.
That distinction is just. It's everything. If the law is supreme, it doesn't just exist on paper. It dominates the entire landscape of consequence. Our ratio establishes this, as you said, inescapable zero-sum relationship, privilege and law. They are fundamentally opposed.
So let's define them. What are these two forces, really?
Okay, so let's start with privilege. Think of privilege as a shield. It's something you have that isn't based on your actions. It's accidental or it's inherent.
Like being born into a powerful family.
Exactly. Birthright, immense wealth, holding a high office, political connections. The whole internal logic of privilege is hierarchy. It's based on the belief that there are different rules for different kinds of people. Its entire purpose is to give someone immunity or at least special treatment when they have to deal with the system that binds everyone else.
So it's personalized. It's inherently anti-universal. It's that little voice that says, oh, the rules, they're for other people, not for me.
That's it. Perfectly. And then on the other side, you have law. And the law has to be the sword of universality. It has to be structured, applied systematically. And this is the critical part. It must operate based on action and consequence, not on identity.
It shouldn't care who you are, just what you did.
Precisely. It asks, did this act happen? Was this specific rule broken? The second a legal system starts to function correctly, this universal lens forces everyone, even the most powerful, to submit to the exact same questions. That protective bubble of status, it has to burst.
So the moment privilege walks into the courtroom, it should just dissolve. It should cease to exist as a protective barrier.
In an ideal system, yes.
It brings me back to an analogy I find useful because these concepts can get a bit abstract. I think of the law in its perfect supreme state as being like a physical constant, like gravity.
I like that. Go on.
Well, gravity acts on everyone and everything the same way.
Yeah.
If a king in his castle drops a gold brick from the top of a tower and a poor farmer drops a stone from his hand, gravity doesn't slow down for the king or speed up for the farmer. It doesn't care about their social identity. It just acts en masse.
Right. Same acceleration.
Exactly. And a supreme legal system has to operate with that same cold, beautiful indifference to identity. The consequence should be tied to the act, not the actor.
That's a powerful image because it captures the non-negotiable force that's required. And for that ratio to actually hold, for privilege to definitively end where law begins, the system needs two elements working flawlessly. And this is where most systems in practice start to fail.
Okay, what are they?
The first one is impartiality. This is a classic image, right? Justice with a blindfold.
Blind justice.
Yes. And the law must be blind not just to wealth, but to political party, to family name, to historical influence, even to personal charisma. Impartiality means that everyone in the system, the judge, the police officer, the prosecutor, they have to actively fight against the natural human tendency to defer to power.
So it's not a passive state, it's an active fight.
It's a constant, active struggle against deference. Because our instincts are to treat powerful people differently. The system has to be designed to counteract that instinct.
But let me push back on that a little. We can talk about blind impartiality, but in reality, aren't these systems built by the powerful, often for the powerful? I mean, practically speaking, the wealthiest people can afford huge legal teams.
Of course.
They can delay, they can obfuscate, they can tie up the prosecution in procedural motions for years. Isn't that a form of privilege that survives, even if the written law is impartial?
You've hit on the core challenge. That's absolutely the tension. The ideal of impartiality applies to the letter of the law, but the access to justice, the practical experience of it, is often dictated by the size of your bank account.
So the process itself becomes a weapon.
It can be. If a case takes a decade to resolve, the wealthy person has achieved a kind of functional impunity, or at least a highly preferential application of the law, not through bribery, but just through attrition. They wear the system down. It shows that the fight for impartiality has to include the equality of resources and process, which is a much, much harder problem to solve.
Okay, so impartiality is the first element. What's the second?
The second is arguably even harder to maintain over time: accountability of the governing.
The people in charge have to follow the rules too.
Not just follow them, they have to be bound by them as strictly, if not more strictly, than the people they govern. If the police can break the law while they're enforcing it, if a minister can just change regulations on a whim, or if legislators can vote to give themselves immunity from normal civil lawsuits, then the whole thing collapses. The rule of law just becomes the rule of men.
It's a sham at that point.
It is. If the people who write the rules are exempt from the consequences of breaking them, they haven't created a system of justice. They've just created a very sophisticated tool for control. It instantly voids the claim of supremacy. The law becomes a piece of theater, not a reality.
And when that happens, public trust just evaporates.
Completely. You move from a world of predictability to a world of whim. And citizens start to see the legal system not as their protector, but as a potential enemy. Or even worse, as just a puppet, and they can see the strings of status and power making it dance. That's the ultimate danger our ratio warns us against. The law has to be a single, universal standard.
We've laid out the theory perfectly, I think. So now, let's see this principle put to the test. Let's see it enforced centuries ago when the stakes were as high as they could possibly be, as detailed in Mr. Muir's research. We need to go from the abstract to a decisive historical action.
Okay, so we turn now to this foundational example that perfectly shows how radical it is to actually enforce that ratio. We're going to the era of the second caliph, Umar ibn al-Khattab.
Often cited as Umar the Great.
Yes, and this specific incident is so powerful because it happened at a time of maximum power for the state. This wasn't a weak government trying to look tough. This was the opposite, which makes the act of accountability that follows so much more profound.
Let's set the stage. What was the geopolitical reality here? We're talking about the 7th century.
Right. Umar was the caliph, the head of a massive, rapidly expanding Islamic state. They had recently conquered huge territories from the Byzantine and Persian empires, including Egypt. He commanded immense resources, a powerful army, and a great deal of obedience. By any standard of the time, he was the supreme political and military authority in the region.
And his officials, his governors, were also incredibly powerful people.
Absolutely. The other key figure in this story is Amr ibn al-As. He wasn't just some local administrator. He was a brilliant military commander, a conqueror, and he was the appointed governor of Egypt. Egypt was a new, hugely important and very wealthy province.
So his son, the other party in this incident, would have carried, just about the highest level of prestige and power that status could possibly give a person.
The absolute highest echelon. He had wealth, a famous family name, and what everyone would have assumed was functional immunity from any real consequences.
And now let's talk about the other person involved, the victim. The sources Mr. Mir compiled often specify that this man was an Egyptian Copt. Now, why is that detail, his identity as a Copt, so absolutely critical to understanding the power dynamics at play here?
It's critical because it maximizes the disparity. It pushes the imbalance of status to its absolute extreme. The man wasn't just a commoner. He was a member of a recently conquered population. He was non-Muslim, a minority. In almost any other empire at that time, ancient or medieval, a person in his position would have had zero recourse against abuse from the ruling elite's family.
It wouldn't have even registered as a crime.
Exactly. The governor's son likely believed, and based on the historical standards of the day, he was right to believe, that his status guaranteed total impunity against anyone, but especially against someone whose social standing was, in that context, at the very bottom. The power imbalance was total.
In the incident itself, the alleged crime was actually quite small, wasn't it? The sources mention a dispute over a horse race or something similar.
It was seemingly petty, yes. A disagreement, a race. And the son, after losing in a fit of what you can only call aristocratic rage, he abuses the Copt, maybe strikes him with a whip, humiliating him and openly relying on the shield of his father's office. He basically says, I can do this because I am the son of the governor.
And, the fact that it was a petty offense is, I think, highly instructive.
How so?
Because when the powerful can get away with casual cruelty, when they can use their status to win a trivial argument with physical force, it sends a message that the dignity of an ordinary person is completely worthless. A system that ignores the petty abuses by the elite is what signals to everyone that there is, in fact, structural tyranny.
That's a fantastic point. It's the small cuts that reveal the deep sickness.
So this man, the wronged citizen, he does something incredible. Against all odds, he travels from Egypt all the way to Medina to appeal directly to the Caliph. This presents Umar with the ultimate test. Does he uphold his political structure, protect his crucial governor, and avoid instability? Or does he risk all of that to uphold this abstract ideal of justice for a low-status, non-Muslim citizen?
And Umar's response, it wasn't a compromise. It wasn't some backroom deal or quiet payment. He chose absolute public justice. He summons both the governor, Amr ibn al-As, and his son all the way from Egypt to the capital.
Which would have been a huge public spectacle in itself.
A massive one. And he doesn't just ask them to submit to a trial. He engineers this dramatic physical reversal of the entire hierarchy.
This is the famous part of the story. He gives the whip, the very instrument of humiliation, to the victim.
He hands it to the Copt and commands him to administer the legally prescribed retribution, the kisses, to the governor's son. In front of everyone, it was the physical act of the wronged person regaining their dignity through a legally mandated public spectacle.
The power dynamic is literally inverted by order of the state.
And then the sources all emphasize this crushing rebuke that Umar directs not at the son, but at the father, at the governor himself. He says, "Since when have you enslaved people whose mothers bore them as free men?"
Wow, that's not just moral anger, that's a political and legal declaration.
It is. It elevates the issue beyond a simple assault case. He's raising it to the level of statecraft. The Caliph is saying, your position, your wealth, your power, none of it gives you or your family the right to treat a free citizen as if they were a slave. If you allow privilege to create that kind of disparity, you are undermining the very foundation of the state, which is built on a promise of inherent freedom and justice for all.
So this one act, it institutionalized accountability at the absolute highest level. It became this powerful, early legal precedent that executive authority comes with responsibility, not with immunity.
Yes, it meant the highest officials and their families were accountable not just in theory, but in tangible, immediate, and, in this case, deeply humiliating ways.
And this brings us right back to our ratio. The governor's son's immense privilege, his political pedigree, his wealth, his family name, it all vanished. It just evaporated the moment the case was brought before the caliph's judicial authority. Privilege was decisively, publicly crushed by the institutionalized force of the law.
This historical precedent established the moral necessity of legal supremacy.
But a moral necessity, no matter how powerful, needs a formal structure to survive across centuries and across different governments. A single great leader isn't enough. So the question becomes, how did this singular dramatic historical act get translated into a global, universal expectation for all modern states?
Right. That incredible historical example gives us the ethical foundation. But for that principle to have any teeth in the modern world, it needs to be systematized. So now we shift from that story to the rule of law doctrine. The role, as it's often called. This is the universal philosophical and structural blueprint for making sure that law, not men, rules a country.
And rule of law is a phrase we hear all the time in political speeches and news reports. But it's often used loosely. We need to define it properly, look at what it actually entails. It's not just a nice idea, it's a very highly structured system.
It is. At its core, the rule of law is the system where all people and all institutions, no matter their status, are subject to and accountable under law that is stable, public, equally applied, and this is key, independently adjudicated.
So it's not ancient. Where did this formal idea come from?
Well, its roots are deep. You can find traces of it going way back. A major milestone is, of course, the Magna Carta in 1215 in England, which for the first time really established that even the king was subject to certain legal procedures. He couldn't just act on a whim. But the doctrine as we know it was really developed by thinkers during the Enlightenment.
People like Locke or Montesquieu.
Exactly. They were grappling with how to prevent the tyranny of absolute monarchs. The rule of law was the answer. It fundamentally means that governing is done by law, not by arbitrary command. And this doctrine gives us three core principles that translate our ratio privilege ends where law begins into a mandatory structure for the state.
Okay, let's break those three down. What's the first principle?
The first is the supremacy of law itself.
Meaning the law is the boss.
In a sense, yes. Supremacy means legal dominance. It dictates that the state's main tool of power is the law. And crucially, everyone in the government, the head of state, the cabinet, the generals, the police, they are all bound by the Constitution and the laws passed by the legislature. If the government wants to do something, it has to be able to point to an existing law that gives it the power to do that. If it can't, its action is illegal. It's called ultra vires, beyond its powers. This is the ultimate check against a ruler just doing whatever they feel like.
Okay, so that's supremacy of law. What's the second principle?
The second is the functional core of our whole deep dive today, equality before the law.
This is where the rubber meets the road.
This is where it all happens. This is the role's mechanism for enforcing that absolute universality of justice. It requires the law to treat every single individual in the same way, regardless of their background, their connections, or how much money they have. But for this to work, it has to function on two separate, really crucial levels.
Two levels.
Yes, substantively and procedurally.
Okay, can you unpack that distinction? Because it sounds like this is where the perfect theory meets the messy, complicated reality of a courtroom.
It is the ultimate tension point. So, substantive equality is about the content of the law itself, the words on the page. It demands that the written law must not be discriminatory. If the law says the penalty for theft is 5 years in prison, that penalty has to apply whether the thief is a homeless person or a CEO.
But surely the law can treat different people differently sometimes. I mean, we have different rules for children and adults.
Yes, and this is where it gets nuanced. The concept of reasonable classification comes in. The law can treat groups differently if there are genuine relevant differences. The example of children versus adults is a perfect one. It's a reasonable classification. But the moment the state starts classifying people based on criteria that are completely irrelevant to the law's purpose, say based on race or religion or what political party they support, it fails the test of substantive equality. It becomes arbitrary.
So there has to be a good reason for the difference. And who decides if the reason is good enough?
The judiciary. The courts. The courts have to act as the referees. They have to enforce a kind of intellectual honesty on the lawmakers. The government can't just say a classification is reasonable. It has to prove that the difference in treatment has what the courts call an intelligible differentia, a clear, understandable difference, and a rational nexus or a logical link to the objective the law is trying to achieve.
An example would probably help here.
Okay, let's say a government passes a law that gives a tax break only to companies located in Province A, but not Province B. The court has to ask, is there an intelligible and non-arbitrary reason for this difference? Maybe Province A is economically depressed and the goal is to spur investment. Okay, that's a rational nexus. But if the reason is just that the prime minister is from Province A, that's arbitrary. The classification fails and the law violates substantive equality. It's the Roel actively fighting systemic privilege.
Okay, so that's substantive equality. What about the other one? Procedural.
Procedural equality is about the process. It's about the experience of actually going through the legal system. It ensures that the journey is the same for everyone. This covers things like the right to a fair trial, the right to legal counsel, the right to confront your accusers, and the right for that trial to happen in a reasonable amount of time.
And this is where the wealth issue we talked about comes back in.
This is exactly where it comes back. When privilege uses its quiet power to, say, buy endless delays, or ensure a trial is held in a friendly jurisdiction, or secure a legal team that's 10 times bigger and better than the prosecution's, procedural equality is being subverted. The written law might be pure, but the experience of that law becomes deeply unequal.
So you need both. You need fair laws and a fair process.
You need both. And finally, the third core principle of the rule of law is legal certainty and transparency. This just means the laws have to be publicly known, clearly written, and applied predictably. You can't have secret laws. If the rules are vague or constantly changing, citizens can't plan their lives. And worse, the state can use that vagueness as an excuse to apply the law arbitrarily, punishing its enemies and rewarding its friends. Predictability is the enemy of privilege.
I have to challenge this on one point, though.
Yeah.
You mentioned the Magna Carta was about limiting the king. But modern legal systems often create special privileges in the law itself. What about things like parliamentary immunity for politicians or diplomatic immunity for ambassadors? Those are explicit legislated forms of immunity for certain classes of people. How does our ratio privilege ends where law begins deal with those?
That is an excellent and absolutely crucial question. It highlights the inherent tension in any real-world system. The rule of law tries to solve this by defining those exceptions not as personal privileges, but as functional requirements of the system.
What's the difference?
The difference is the purpose. For example, parliamentary immunity, in theory, isn't there to protect the politician as a person. It's there to protect the legislature's ability to have free and open debate without members being afraid of getting hit with politically motivated lawsuits designed to silence them. Diplomatic immunity is a function of international law, designed to protect the sovereignty of nations.
So they're tools for the job, not perks for the person.
That is the justification. The role can accept these functional immunities, but only when they are very narrowly defined, strictly applied, and most importantly, they do not provide a shield from criminal acts or flagrant abuse of office. The moment parliamentary immunity is used to hide corruption, or diplomatic immunity is used to shield someone from a serious crime, it stops being a functional requirement and it reverts back into the pure, toxic privilege that our ratio condemns.
That's the boundary line. The moment it becomes a personal get-out-of-jail-free card, the rule of law has failed. Okay, so we've gone from a historical moral act to this complex, universal philosophical doctrine. Now, let's bring it home. Let's see how a modern state tries to lock this ideal into its most fundamental legal document. We're moving now to the modern expression of this whole idea, focusing on Pakistan's constitution. Specifically, a critical provision known as Article 25. This is where the principle that Caliph Umar enacted so dramatically all those centuries ago gets formalized into a mandatory legal command for a contemporary state.
Article 25 is, without a doubt, the constitutional guardian of equality in Pakistan. It takes that abstract principle from the rule of law doctrine and codifies it. It makes it the highest law of the land. It gives citizens a direct, enforceable right they can use to challenge the state if it acts in a discriminatory or arbitrary way.
Let's get the exact text out there, because in law, every single word matters. What does it say?
Article 25 states, all citizens are equal before law and are entitled to equal protection of law.
It's short, but it's packed with meaning.
It is. It demands two things: neutrality from the law itself, and uniform enforcement by the entire machinery of the state. It's the constitutional answer to the persistence of privilege.
We really have to deconstruct the two distinct ideas in that one sentence. Start with the first part. Equality before law. What does that piece actually guarantee?
This clause is primarily about procedural and jurisdictional parity. It means the law cannot create special categories of people for judicial purposes. You can't have one set of courts for the rich and another for the poor. You can't have a more lenient legal code for government officials. There can be no privileged access point to the justice system.
So this is the anti-status mandate.
Exactly. It ensures that the modern equivalent of the governor's son from our story can't demand a trial in some special sympathetic court that's designed for the elite. It mandates that everyone, regardless of their position in society's hierarchy, stands on the same level ground when they face the judicial process. It's about jurisdictional uniformity.
Okay, that's equality before law. What about the second part, equal protection of law? That sounds more active.
It is. This is the operative mandate. It's a positive command to the state. It controls the content of all subsequent legislation. It means the state has to apply the laws it already has uniformly, and crucially, any new laws that create classifications among citizens have to pass the strictest constitutional scrutiny.
So this is the part that gives the judiciary the power to police the legislature.
Yes. The courts, acting as the sentinels of the Constitution, can use Article 25 to review laws passed by Parliament. If Parliament passes a law that violates this principle of equal protection, the courts can strike it down. It puts a mandatory constitutional brake on the ability of lawmakers to create new forms of privilege.
So how do the courts actually do that in practice? How do they decide if a classification in a law violates equal protection? You mentioned those tests earlier, the intelligible differentia and the rational nexus. Let's see how they work under Article 25.
Okay, so when a law is challenged in court under Article 25, the burden is on the state, on the government, to justify why it's treating one group of citizens differently from another. The courts apply a two-pronged test that's derived from jurisprudence around the world.
Wrong one.
First is the test of intelligible differentia. The classification has to be based on a genuine, discernible difference that is relevant to what the law is trying to do. For example, if a law gives tax exemptions to small businesses but not large corporations, the distinguishing criteria, the size of the business, is intelligible. You can clearly define it. But if a law gave tax exemptions only to people whose last name begins with A, that's purely arbitrary. It lacks an intelligible differentiation.
It's a meaningless distinction.
Yeah.
Okay, what's the second prong? The rational nexus.
This part is critical. The difference you've identified, the differentia, must have a rational and direct relationship, a nexus to the objective the law is trying to achieve. So let's stick with the business example. The objective of the law is, perhaps, to encourage entrepreneurship and support the local economy. Providing a tax break to small businesses has a rational nexus to that objective. It makes sense.
But giving a tax break to people whose name starts with A doesn't help the economy.
Exactly. It has zero rational nexus to the stated goal. So if a law fails either one of these tests, the courts will rule that it violates the Equal Protection Clause of Article 25. They'll say it amounts to arbitrary status-based preference. It is, in effect, legislated privilege.
And the power of Article 25 is that it forces this kind of logical rigor on the government. It prevents a political majority from just writing laws that benefit their friends or penalize their enemies.
It forces all law to be based on reason and public good, not on malice or favoritism. It's a powerful tool.
It provides the citizen with the legal weapon to fight back. And if we connect this all the way back, Article 25 is the mandatory modern legal mechanism that ensures the kind of accountability Umar enforced centuries ago is still legally demandable from the state today. It's the guarantee that a modern official's family can't rely on influence to escape justice.
That's the ideal.
Right. And we have to talk about the tension between the ideal and the reality. A constitutional guarantee is powerful, but it needs institutions, judges, police, bureaucrats who are strong and independent enough to actually enforce it against the constant pressure of wealth and political power. How does that tension play out in the daily application of Article 25?
That tension is a daily battle. The state, especially the executive branch of government, always wants more discretion. It wants leeway. But unchecked discretion is the doorway through which privilege re-enters the system. For instance, if a law is written in very vague language, it gives the government agency in charge wide discretion in how it's applied.
And that discretion is almost always going to be used to help the well-connected.
It's almost a law of nature. So Article 25 forces the courts to try and narrow that discretion. Judges are constantly interpreting legislation to make sure that its implementation isn't arbitrary. The fight isn't just about the beautiful words in the Constitution. It's about the constant judicial vigilance needed to make sure the spirit of equality isn't choked to death by political convenience, corruption, or simple procedural bias.
So in the end, the real-world success of Article 25 is directly proportional to the independence, the integrity, and really the courage of the judges who are tasked with wielding it. That's what separates a constitutional promise from a lived reality of justice. #B synthesis and the supremacy of justice. Okay, so we've come full circle. We've traced this incredible principle, the supremacy of legal equality, from a single morally defining act by Caliph Umar.
A moment of profound leadership.
Right. Then through the intellectual architecture of global rule of law doctrine, and we've landed in the specific enforceable mandate of Pakistan's Article 25.
And the synthesis, the common thread weaving through all three, is crystal clear. It's this uncompromising demand for the supremacy of equality. Without it, a legal system just loses its legitimacy. The state reverts to a model where might makes right, where power dictates the truth instead of the law.
So the only way to get stability, the only way to guarantee the inherent dignity of the citizen, is to make sure that status and influence are categorically neutralized inside the halls of justice.
They have to be.
Let's try and crystallize this for the listeners. Boil it down to a couple of key takeaways. The first one, I think, have to be a pretty sober understanding of how fragile this principle really is. Equality before the law is not the default setting for human society.
Not at all. It's the exception.
Human political structures, they just naturally seem to tend toward hierarchy, toward stratification, the concentration of power. They're constantly generating new kinds of privilege, financial, bureaucratic, political, that try to shield the elite from any real consequences.
A constant pressure.
Exactly. Which means the supremacy of equality has to be this active, constant state of defense. It requires judicial and civic vigilance. The second that vigilance relaxes, privilege, like a corrosive acid, it starts to seep back into the system. It comes in through selective enforcement, through procedural tricks, regulatory capture. It's a perpetual war of ideas.
And that fragility is why the system needs to be tested constantly. The moment a powerful politician, an influential CEO, or a high-ranking general commits an abuse, the spotlight is on. The world is watching. Will the system hold? Will Article 25 actually be enforced? The answer to that question tells you whether that society is still operating under the rule of law or if it's fallen back into the much older, much more brutal rule of men.
So that's takeaway number one, the fragility and the need for constant defense. What's the second?
The second takeaway is about the power of knowledge and language for the citizen, for the learner. Understanding these precise foundations, our ratio, the principles of the Rowell, the constitutional safeguards like Article 25, it's an incredibly empowering tool. It lets you move your critique of injustice from just, a vague moral complaint.
From just being angry.
Right. And it moves you into the precise language of statecraft and constitutional law.
So instead of just saying, that's not fair, you can actually articulate why it's not fair in the language the system is supposed to understand.
Precisely. If you can say that a government action is failing the intelligible differentia test under the Equal Protection Clause, or that an official is violating the historical principle that privilege ends where law begins by using an administrative loophole for personal gain, you are no longer just arguing for your preferred outcome. You are arguing for the integrity of the state itself. You're defending the very architecture of justice that is supposed to protect your own dignity.
It gives you a stake in the system's integrity.
It does. And ultimately, I think this deep dive proves that the demand for justice is universal. It doesn't matter if it's being applied by the powerful moral authority of a caliph in the 7th century or by the structured, formal mandate of a modern constitutional court interpreting Article 25. The core requirement is identical. The law must be the ultimate master, and privilege must be its very first casualty. #tag outro.
This has been a really profound exploration, I think, into the very foundations of governance. And it was all powered by the excellent research compiled by Mr. Zahir Ahmad Mir. We've confirmed that the law's greatest power, its most important attribute, is its required blindness, its ability to ignore the differences between people in order to enforce a single, consistent standard of conduct and consequence.
And I think the true measure of a just system isn't found in the laws that tell the average citizen what they must do. It's found in the foundational legal principles, like Article 25, that tell power, in all its forms, what it cannot do. Those are the principles that constrain the state and the elite. That's where freedom really lives.
And that brings us to the final provocative question that we want to leave with you, our listener, to continue your own thought process on this. We've established that the law should be supreme and that the Constitution provides the ideal, like in Article 25. But how do we ensure that the vast, complex, and often politically motivated systems of enforcement, the police, the investigators, the bureaucracy, are also held absolutely accountable to that privilege ends where law begins ratio?
It's the enforcement gap.
It's the ultimate enforcement gap. What specific non-textual mechanism, beyond just hoping for a brave judge to step in after the fact, is needed to ensure that the people who actually implement the law are forced to adhere to its highest, most impartial standard, especially when they are the ones who hold the coercive power of the state in their hands?
A huge question.
It's one to chew on. Thank you for joining us on this deep dive into the supremacy of equality. Keep asking those profound questions, keep digging into the sources, and keep learning. We'll see you next time.